matter to December 16th for motions, 9 o'clock in this courtroom, same release. Thank you.
Thank you. Thank you, Your Honor. Have a
You're
good
welcome,
day.
sir.
Elaine Moon versus Chatot Davidson et al. Before the judge. Please identify yourself for the record.
Elaine Wu.
I don't think you want to go over there.
Yeah, fine. Where are you? You in the
Sarah Green from Millipore.
Oui. Yes, Ms. Wu, it's your motion.
Yes, I would like to quickly summarize my case because I did not get to do it in my last hearing. So this is a case about defamation and retaliation from whistleblowing, which resulted in a dismissal. And I put defamation first because Jacoto was aware of her mistakes prior to my arrival, and she immediately asked me to cover up for her during my first week before I started to work in earnest. Subsequently, because I was sick and working at home, I had to point out some other mistakes which were all in writing, and her responses were to tell me that there were not really any problems because they're not marketing and sales. However, this project was about global, not just marketing and sales, and it's about all HR functions, not just marketing and sales. So I just want to make that clear that the dismissal perhaps was premeditated before I even arrived. So I would like to say why I'm requesting reconsideration. It's based on my understanding of Rule 60, that there were documents missing and perhaps judges changing. And the defense took this case to be about Jacotot, not Jacotot Davidson et al. And with EMD Millipore named as a party. As a result, her complaints about deliveries not making to a specific person was mistaken because it could be made to a company designated representative, as I have delivered properly. The defense also misrepresented, due to that misunderstanding of any accounting financial matters, which Jacotot was not an expert. And any other facts about this project are misrepresented because I believe it was primarily Jacotot's voice. And none of these statements made were backed up with evidence. So, if I may, I wrote an affidavit, and may I present that? I will only reference them, but this would be for the court's record.
Is it something you've already filed, Ms. Wu?
No, it is what I'm saying today, and I thought it might be easier to reference later. So I formed this document according to the defendant's motion for opposition. And I would want to jump into the details right away because I know we don't have a lot of time. So the defense said that I did not establish that the court made a clear error of judgment. So I'd like to say that because the judge changed, he did not have the background, and he had to be reading it while I was speaking. And then the ruling judge...
I'm sorry, I didn't hear you. You said what?
The judge who heard me was not the scheduled judge, and he was not prepared for the case, and he had to read the notes while listening to me. Then the ruling judge was not the one who heard me, and with documents missing, it was very unlikely that this decision could have been made fairly. I would also like to say that the statement of damages, which is a required form, was also missing in that folder, along with the supplement that detailed the claims and relief. So even without a motion to dismiss, I would have lost because these are required documents. Furthermore, I did not receive my first hearing notice from the court, so I would have lost without appearance. I'm a citizen of the United States, and I plead for equal civil rights, justice, and fairness. This is protected under 42 U.S. Code 1981, 1985, etc. Part B, the defense misrepresented. It complained that my trying to establish credibility in IT, accounting, and finance fields were irrelevant. However, this is a key point in opposing the defendant's positions because this project was financial. And I would also like to say that under process, I'm permitted to deliver to the company contact under Rule 42, and I had this document served to EMD's official designated contact, Ms. Denon, who's executive assistant to the corporate legal counsel of EMD Millipore. Under Rule 5A, party is a company. So Part C in the defense position, the supplement was properly part of the complaint. It was sent to EMD Millipore before Littler was hired for representation. I can also prove that the supplement was missing. First of all, the defense has never referenced it. Therefore, it knew it was missing. Secondly, after the judgment for dismissal, I came back to the court and asked to see the folder, and I found that it was missing, and the clerk confirmed that with me. Next, I came back again to double check to see all the forms were there, and I was given a separate folder, the green one that you have, and it had all the forms, unlike the other folder from the hearing. And it had the statement of damages, but not the supplement. Lastly, I went to the online document log for the court, and it is missing as well. And you can see that I attached it. The supplement is not in the time log. Part D, the defense complained that I repeatedly failed to follow civil procedures. If the defense faults me for that, it must also fault the court, because I repeatedly asked the court's help for the procedure. About the supplement, the clerk responded that any document can be filed by me, but no one may read it until a hearing is scheduled. And I found this to be correct, and in particular for the supplement, Rule 15D allows that if the court allows it. And then all the rest of the Rule 15 I found allow amendments. 15A, matter of course, 15B, conform to evidence, and 15C, relation back. And of affidavits, the civil procedure allows 1 day filing before or at the hearing. Lastly, I would like to put forth something about civil rights. In President Lincoln's Gettysburg Address, he said, "This nation under God shall have a new birth of freedom, and the government of the people, by the people, for the people, shall not perish from the earth." November 1863. Therefore, I plead the court to let this case go forward without prejudice.
Thank you, Ms. Wu. Attorney Green?
Your Honor, I appreciate Ms. Wu's passion, but obviously before the court is a complaint that was the only complaint that was properly filed. We moved to dismiss that complaint. The motion for reconsideration advances 2 grounds upon which to reconsider the court's allowance of our motion to dismiss. One is broader misrepresentation by defendants. However, there's nothing in the motion for reconsideration that suggests that we engaged in such broader misrepresentation. Instead, she references her apparent background and skill set. In addition, she discusses a clerical error in terms of the supplement being missing from a folder. It sounds like maybe it was in one and not in another. Our position is that the evidence suggests that she did file that supplement with the court, but regardless, she did so after filing the complaint and after serving the complaint on defendant. It was not an amended complaint, and we certainly properly did not address that in our motion to dismiss the only complaint properly before the court.
Thank you. Take the matter under advisement. Thank you very much.
Thank you, Your Honor.
You will be notified. Thank you.
Thank you.